Can you imagine a real estate guru voluntarily allowing himself to be interrogated and cross-examined by a real estate attorney about his documents and his process for 2 solid hours and for all the world to see? Well, you don't have to imagine anymore. You're going to get to hear it live.
I have come here to chew bubblegum and kick ass, and I'm all out of bubblegum.
This is the Virtual Real Estate Investor Podcast with Vincent Polisi. Buckle your seatbelt and prepare to learn how to legally make 6 figures investing in real estate with no money, no credit check, and nothing but a computer and internet connection. Learn how you too can begin generating buyers and sellers for free today, and why you're only 2 calls away from making a $10,000 or more payday while never leaving the comfort of your home. And now, your host, the virtual real estate investor, Vincent Polisi.
All right, here we go. Welcome, Investor Nation. If you listened to the prior episode 006, you got to listen to our very first ever hot seat webinar where I cross-examined and forensically audited the real estate contracts known as a lease option that are being sold by another guru. And we actually had the attorney that prepared the documents on the webinar with us. And you're going to get to listen in as I go through these contracts line by line, clause by clause, and vet out all of the different parameters that make these documents and agreements not in compliance with state and federal law, violations of Dodd-Frank, violations of the IRS installment sales contract guidelines where you're creating bona fide sales through what's called a disguised sale or a de facto sale, as well as a number of other things that you'll get to hear in that episode. Now, after we did that, when we did a survey of all of our Facebook fans and all of our email list subscribers and asked everybody, okay, who would you like to have next in the hot seat? And the attorney that I interrogated in the very first hot seat webinar said, hey, what about you? And I'm like, you know what? Absolutely. Let's go. I'm all for total transparency. I'm sick and tired of all these other guys shilling these courses out there where they will not stand behind or defend or document what it is that they are selling you, nor will they show you that they're actually using it themselves 9 times out of 10. So I said, absolutely, let's do it. That's what you're about to get to hear. And what happens is in the next 2 hours, I get cross-examined backwards, forwards, upside down, you name it. They brought in another investor to add a different panelist. We have Bill Walston back from the very first webinar that we did, who's a CPA and real estate attorney, lending his expert advice and guidance on real estate taxation. And you're going to get to hear exactly what the process is that I use, how it's done, and what a real estate attorney thinks he can do to pierce through it. So enjoy.
Hey, what's up, investors? John Lee Dumas here, founder and host of Entrepreneur on Fire, awarded Best of iTunes 2013, and you're listening to the Virtual Real Estate Investor Podcast with my man, Vincent Polisi. Prepare to ignite.
You think I'm talking about breaking the law?
No, I'm just trying to figure out how far you want it bent.
As far as you can without breaking it.
And now, it's time for No BS with the virtual real estate investor, Vincent Polisi.
First of all, I want to thank every one of you for attending our second episode or session of the hot seat. Last week, if you were a party to that, we had real estate attorney Angelo Russo as he sat in the hot seat, and we took him to task line by line through some of the contracts he uses and the process that he goes through on lease option deals. And Bill Walston, Scott Moyes, and I shared our experience with why we did not care for that contract or the methodology with which he was doing lease options. And so when we put out this week that we were looking for another person to sit in the hot seat, Angelo said, well, hey, what about you? And I was like, yeah, that's fine. Turnabout is fair play. I don't have any issue with that. I'll sit in the hot seat and you guys can grill me, and we'll have total transparency on exactly what we're doing, how we're doing it. And Angelo has got 1 or 2 other people here. You're going to have to introduce them because unfortunately I don't know either one of them. Angelo, you want to tell them who you've got?
First guy is Rob Gillespie. He's known as Rob the House Guy, and I'll let him introduce himself. He's here with me.
Hey, how you doing? Thanks for having me on, Vince.
Oh, my pleasure. Thanks for coming on.
I've been a real estate investor about 18 years, done 1,000 deals or so, and I actually use Angelo's paperwork, the lease option. We don't do a ton of those, but when we do, that's what we use in the lease option flips.
Okay, awesome. Yeah, and you weren't party to the webinar last week, so I think I clarified in that several times. I have done tons of lease options, done them on personal deals for myself, for houses I've lived in on numerous occasions, have done tons of lease option deals with clients and used almost identical paperwork to what he's got in an almost identical process. So it isn't as if we're trying to spew mud. It's just things have changed, and certain other scenarios have come up where when you're dealing with what's called a de facto or disguised sale under the eyes of the IRS, and the equitable interest argument that can be conveyed in a lease option deal with rent credits and or deferring the maintenance and repair issues and things like that over to the tenant, you can run into a lot of different issues. And so we got away from that back in late 2008, early 2009, where we went to strictly a contract for deed, land contract for the rent to own type deals I'm talking about. We do full spectrum investing, but at any rate, for those types of transactions where you've got a buyer and a seller, we're just going straight in with a contract. And actually the contract that Angelo has is one that we're actually just now coming out of the gate with. It's taken us quite some time to get things. It's a modification of the contract for deed that I've been using for years that was actually prepared by an attorney in Atlanta that is also an investor, but also litigates this stuff, that I actually ended up doing a deal with him on a few homes that he had as well. So,
you're doing a contract for deed. What state are you in?
It depends on when you ask me. Right now I'm in Scottsdale, Arizona, but I don't do local deals. We do deals virtually all over the United States.
Okay. All right.
So it could be, I could do a deal today in New Jersey. I could do a deal tomorrow in Florida. It could be, next week. I don't know where you're at, but right there. And depending on what state it is, it could have a different name. It could be a land contract, installment sales contract. California requires, I believe it's called a grant deed. There's any number of variations of owner finance agreements that are in compliance with the IRS's installment sales contract guidelines. And I'll give you a little background here on how we got into going in that direction before Angelo tears me apart here. Basically, the issue that we had back in 2008 was that we were doing lease options and the lender started tightening up on things. They stopped letting us do the 100% rent credits. We knew the situation, like I pointed out on Angelo's contract last week, with deferring maintenance and repairs to the tenant was something that everybody does on every lease option contract if they're smart, but will not hold up in court, and you can get yourself into all kinds of trouble with it. So we were doing all the exact same. I mean, it's, lease options are not rocket science. It's been the same thing for, 30 years that I know of. And at that time, when we ended up doing the deal with the real estate attorney, I told him, I said, look, my preference here would really be to do a contract for deed because, the point here is an actual sale. What I don't like about the lease options is that you have a seller or, landlord technically in that scenario that is on the hook for 24 months under our contracts under the normal term, and he's required to sell. He's got all the liability. He has all the risk associated with whether this guy tears the house apart and leaves in the middle of the night or not. And ultimately, at the end of the day, the buyer is under no legal requirement. I say buyer again. We're switching up terms. The tenant, which the original intent, just like with Angelo, was for the tenant to buy. He's under no obligation under the option to do that, and that's not really what we're trying to do. But the issue that we have is that we don't want to get involved in the equitable interest argument where a tenant comes in and throws a kitchen sink at the landlord based on the contracts that we have, invokes equitable interest, and now the landlord/seller has to take him through the judicial foreclosure process before he can evict. And now we're in 4, 5, 6, 7, 8 months, depending on what municipality that you're in. Excuse me, I'm going to close all this out so we can get this noise going. And so, that's not really, we didn't want to set up a seller with a ringer that was going to hang him out to dry. Right. And so the attorney comes back to me and he says, Vincent, we can contract for anything that is legal to contract for, meaning we cannot put together a contract to buy and sell cocaine because that is illegal. But what we can do in these contracts is put in 2 separate clauses or provisions that would enable us to legally move forward with a contract for deed on a property and have in place what is called a triggering event clause and also what is called a conversion clause. And the triggering event is a default or a material breach of contract with which then you can sue for specific performance and breach and move directly into, as you'll see the way we have it set up, into an eviction at that point. And that's the triggering event clause that then triggers the conversion clause. And the conversion clause is a waiver of all rights associated with the property to take the technically the owner at that point, the buyer who moves over into the position of borrower, take him out of his equitable interest position and move him directly into a tenant at sufferance scenario so that you can move directly into the eviction process. And so I said, Michael, that sounds fantastic. I love it, want it, could sell it all day long, but here's the problem. Nobody's going to believe me. So if that's the case, then what I need you to do is I need you to put that together and provide me the supporting case law that backs up what you're saying. And I want you to sign on the line, which is dotted, and provide me a letter of opinion on your letterhead that is also the case. Okay. So, and no offense to Angelo, but attorneys have a bad habit of saying things. And because most people are out there, they're not familiar with dealing with them. They take it as gospel. They don't require the attorney to proof up. And that's how people get hung out to dry by attorneys in court all the time. So I was like, that's fine. I totally, if you're correct, I love it. I want it. I'll pay for it. Not a problem. But I need to see it in black and white. I need to see all that. So he did that. He actually put it together. We ended up doing a deal on one of his houses that way. So I had a much greater confidence that he had faith in what it is that we were putting together and doing. And I will have to tell you this up front in, it'll be like total transparency here, that we have never been tested in court on these documents. Okay. And part and parcel to that, it kind of goes back to Angelo's argument last week, which was that he's setting up, he's setting up his contracts knowing that, there's a strong likelihood that he's never going to have to fight it in court because the average tenant is not going to be educated or have the income to be able to fight him with an attorney. And in this situation, we have been, for the last, since I guess 5 years or so, utilizing a variation of the contract that you guys are about to see. And I'll tell you here in a second what the added twist to this one is that came out as a result of Dodd-Frank. And because of the pre-qualification that we do with buyers, because I am underwriting all the files, utilizing standard mortgage lending guidelines. I spent 12 years in mortgage banking and owned a mortgage company, so I've underwritten thousands of loans all over the United States. And we are, calibrating debt to income ratio. We do not put buyers in properties with the intent for them to fail so that we can then double dip and hit them for another option fee or assignment fee or down payment or increase their payment and price. I know a lot of investors do that. These deals are actually structured from the very beginning to succeed, and we're ensuring up front that the buyer has the legitimate ability to qualify for conventional financing during the contract term. So if, in other words, he had a judgment that he did not have the financial ability to pay off during the contract term, we know that he is not going to qualify in 24 months. And so we have to do one of two things, and that's either stretch the contract term out to a point that he has the financial ability to pay it off, or find another source of revenue that can pay off that judgment or tax lien or whatever it is for him. And if it's a foreclosure or short sale scenario, obviously we understand the seasoning requirements that lenders have. And so we're making sure that the contract term is long enough for them to meet that seasoning requirement. And I've seen guys do this before where they knew somebody had a bankruptcy or a foreclosure and they knew the seasoning guideline was either 24 or 36 months, and they'll put them in a 12-month contract knowing that they're going to, have to come back to the well 12 months later and they're going to knock their head off for another option fee. A lot of guys make a lot of money doing that. I didn't want to be in that type of business. And so what we endeavored to structure from the get-go was a true win-win, a really, a great benefit for the buyer/borrower that basically accomplished what his goal was, which was home ownership. And then he gets the added benefits of the tax deduction. And at the time when we started doing this back in 2008, those of you who have been in the business for a while will remember this. The IRS had what they called the first-time home buyer tax credit, which is really a misnomer because it had nothing to do with first-time home buyers. You could be, we got it from my in-laws who were in their 60s at the time. But they called it the first-time home buyer tax credit. And essentially what could happen is if you purchased a property, you could have gotten back $8,000 in cash, okay, is actually, it's not a refund. Because it's not money you paid in. It was actually a tax credit, but it came back to you in the form of cash from the U.S. Treasury. $8,000 if it was your first home or you hadn't owned a home. I believe it was in the prior 3 years, and $6,500 if you had, and you have to, I'm a little fuzzy because it's been a while, but $6,500 if you had owned a home in the prior 24 months. And so at that point in time, what was happening was the National Association of Realtors was going head to head with HUD because they had eliminated the Nehemiah program, which was the down payment assistance program. And so they got into a chicken or the egg situation where people were going to be, provided this $8,000 or $6,500 within, could have been a couple of weeks, 2 to 12 weeks after they closed. And so the NAR came out and said, well, hey, HUD, since this is actual cash that the U.S. government, who supposedly is who HUD is also, is going to be issuing to our buyer, why can we not utilize that as their down payment funds or as a credit towards their down payment funds, validating that it's coming back to them? And HUD came back and said, no, you can't do that. What you can do is you can use it for additional down payment above the LTV requirement or for closing costs and prepaid items. And so everybody was in a big hullabaloo and uproar. But at that time, with these contracts that we have, because they were put together in compliance with the IRS installment sales contract guidelines, basically what I did was I brought in a real estate attorney in Atlanta. And then I have another client of mine who we did a deal with in Alpharetta, who worked for the largest CPA and business advisory firm in all of Georgia. And he brought in his partner who had 26 years in real estate taxation. And we vetted this thing 7 ways from Sunday to make sure that they were going to be in compliance. And so what we had then was, for those of you guys who have seen the credit repair video that I did, where we have Sarah, who came to us with a 376 credit score, 31 derogatory accounts, and in 69 days doing what we told her to do, she had legally eliminated 28 of the 31 derogatory accounts and increased her score by 191 points. That client right there came to me with the 376 credit score. We got her into, it was about a $318,000 brand new construction property that we had under contract with a bank because we were doing deals with a special assets manager who had complete control of their entire REO inventory. And what they'd done was foreclosed on a bunch of builders who couldn't sell the houses. Well, none of the bank had them. They couldn't sell them either. And so they ended up doing owner finance deals. Well, we got her into that property, and about, I think it was 8 weeks later after she closed, she ended up getting back $8,000 from the IRS for the first-time homebuyer tax credit because the contracts that we're using are actual bona fide sales as far as the IRS is concerned. So that's basically the background and foundation of how they all got going to begin with. It was designed to be a really good deal for a client that they really weren't getting anywhere else as far as the buyer is concerned. Also to have the protections in place for a seller in the event that things went upside down. And we had the provisions where they're waiving, rights to trial by jury and waiving their affirmative defenses and basically waiving everything other than whether or not they paid. Now, what's happened since then, and I'm sorry to be going so long here, but I want to give you the background and foundation so it makes sense. What's happened since then is we've had the lovely introductions of two things called the Safe Licensing Act and most recently here, Dodd-Frank. And so when we knew that Dodd-Frank was going to come and knock us over the head with a big club on the owner-financed, or let me rephrase that, the owner-occupant owner-finance deals, we started last year basically working to develop a scenario that would allow us to continue doing business as usual without having to constantly worry about, for ourselves or for our clients, whether or not Dodd-Frank was going to come knocking. And so through that process, it took me a few months, and we had a lot of conversations, a lot of emails back and forth, a lot of chats, a lot of just, doing our due diligence and vetting the process with Bill Walston, who's on the call here as well, who's a CPA and professional investor, John Kustin, who's also a member of our group. And essentially what we determined at that point in time was that in basically reverse engineering Dodd-Frank, what we could do is we could go as a company, direct purchase the property as a non-owner occupied purchase, because this is under owner finance with no money down, so it makes sense. Under a non-owner occupied purchase, which Dodd-Frank does not regulate, And then, so we didn't have to come out of pocket and start making payments because I don't like doing deals where I don't have the property sold already, where there's any expectation of payment. Do a seller leaseback up until the point in time that we have identified a buyer that we're going to, or an assignee technically, that we're going to assign our contract for deed to. And this became, the proprietary methodology that we worked on so that we could continue doing things the right way legally, but not invoke any issues with Dodd-Frank at that point. And so now that I have probably put most of you to sleep, I'm going to let Angelo take over, and I'll bring up the contract if that's what you want me to do, Angelo.
Yeah, go ahead and bring it up.
Maybe I won't.
So a couple questions, not exactly on the contract while you're bringing that up.
Sure.
Do you record these with the county?
Well, we had not been previously, but now there's a clause in here that allows us to record a memorandum or the contract for deed because the lenders are requiring it for chain of title now. They didn't used to do that.
So how does this not trigger the due on sale with the banks?
I never said that it didn't.
Okay.
Because due on sale is and we've had this conversation sort of ad nauseum before, back and forth in all the groups and everything. Due on sale is the urban myth boogeyman that everybody talks about, but nobody ever knows anybody that's ever actually been through it with the banks.
I've seen it done on a commercial property. I haven't seen it done on residential.
Right. Well, if I can address that real quick. Basically, the due on sale clause, for those of you guys who don't know, who've never actually read a mortgage or a note, essentially indicates that if there is a transfer of title, that the bank can accelerate the note and require a payoff within, 30 or 45 days. And so if you get in all these REI groups and you're on Bigger Pockets and you're on Facebook and Google Plus and all this stuff, you're going to hear people with this scare tactic of due on sale. You're going to trigger the due on sale, and all of a sudden the whole deal is going to implode, and either the seller is going to be required to refinance it or he's going to be foreclosed on. Now, in 30 years, I've never met anybody that this has ever happened to unless this has been met, unless they were in default. Okay. The reason for that is that banks are in the interest collection business. They are not in the real estate business. And as long as a payment is being made on time, there's never any reason for them to have any desire to want to accelerate a note, with the exception of if they get into a capital reserve issue where they are short and they are at risk of the FDIC coming in and taking over the assets. And for that to happen, it has to be either a 2008 type scenario, 2007, 2008 type scenario, or 1929 with the Great Depression, where they were allowed to invest and they were investing on margin and had short funds and all that kind of stuff. But I'm not saying it can't happen. It's like anything else, Angela. There's no absolutes or anything like that. I've never seen it happen. I've never talked to anybody that's ever happened to. And in the state of Georgia, as an example, when you close for every house I purchased there and I actually got conventional financing on, I was the borrower. I was the person that was on title, and I was the only one that was allowed by the lender at that point to be on title and deed when the transaction closed. What real estate attorneys in Georgia do for married couples that want the wife on the title or the deed is that as soon as they close, they immediately have another deed executed and they get recorded simultaneously. And all of the lenders are aware of this. It's standard practice in Georgia, and they don't accelerate the notes because of it, even though you've now got somebody else that could potentially, in theory, cloud the title. So, but yes, no, we've never had the due on sale clause accelerated, nor have. And I'm not saying that it couldn't.
Right. Well, this is Rob, the house guy, chiming back in. I can completely appreciate the urban legend, because a lot of people get involved in real estate and they're scared to death to make a move because of the urban legends and what might happen. And I'm going to take that back over to the lease option or lease purchase paperwork that we utilize and you're talking about gaining equitable interest by someone doing work on the property. I've only been to eviction court once, I think, in the last 13 years, and they didn't even show. So I've never had any of that happen, nor have I heard of it happening. So I'm kind of with you that the urban legend thing of gaining equitable interest off of doing work on a home it doesn't scare me, just like the due on sale doesn't scare you.
Right. Yeah. No, I hear you. Like I said, we did it that way for years. When you talk about work on the home, you're talking about repairs, I'm assuming, where you've shifted the maintenance and repairs to them.
I was just letting Rob know that it happened to Lisa, that someone challenged it. If that was your whole point of bringing her on, that she had to go to court and defend the documents.
Well, my point in that was not that it was because of maintenance and repairs. My point in that was that she had bought a course and had poorly slapped together incoherent contracts that really didn't apply, that was used, and that's one of the reasons why she couldn't get an attorney to defend her in that scenario, is because she bought something from one of the internet marketers that sells those things, and had nothing really to do with the maintenance or repair issue, even though that was in that agreement.
Well, I'm not a guru. I'm just an investor like you are that's been doing this forever, and I take on some joint ventures just like you and partner with people. I'm not saying I'll never sell books or tapes or do any of that, but this time I don't. And that is a problem. You get a lot of these folks that'll get out there and they'll buy books and tapes, and a year later they just regurgitate someone else's material that's never been tested and sell it. But it's really in the hopes that the people will never use it anyhow, so it doesn't matter.
Right.
But I'm with you on that. Some of these things that are being produced and sold are more dangerous than they are good.
I completely agree. That was kind of the point last week. So at any rate, go ahead. Angelo, what else do you have?
Only because you like being nitpicky on the first one. East Haven is a city, not a county.
I beg your pardon?
East Haven is a city, not a county.
Okay. It may be.
But under your default provisions on, page 3, section 10?
Okay.
You have that, and I'm going only by Ohio law, not by everyone else, all the other states that you deal with.
Right.
But you want to, the triggering clause and the conversion clauses that you were talking about, where it just makes all the payments security deposits and they waive all of their rights. Court won't enforce that. You can't waive affirmative defenses ahead of time, especially in real estate agreements. I'm going to try and say, I think did a little bit of research, and I think it was, in case you want to look it up, and that applies specifically to lease purchases, which this might be construed as a lease purchase, but it's Ohio Revised Code 1350-103, where specifically you can't give up your affirmative defenses.
Okay, I'm not arguing with you. I'm not familiar with Ohio code. I've never done a transaction in Ohio for this type of deal.
Because our values are too low for you.
I didn't say that.
There's only a handful of areas that will have this $750,000. I think you have a sale price over there.
Yeah.
But you also have, I think it's the fourth line down, immediate possession of the premises. They're going to strike that, mostly because that's more of a commercial type of clause. You cannot take immediate possession of the premise. It's known as self-help, and if you do it, they're going to come down with a hammer on you.
I agree. Totally agree. Angelo, just like you, we have clauses in here that are designed to get the point across up front that we know are not going to be enforceable in court, but, or let me rephrase that, that may not be enforceable in court depending on the judge. Now, we have had, fortunately, in the last 7 years, we've only ever had one seller ever make it into court with any of our tenants or buyers or whatever. And to kind of give you some background on how that whole deal went, essentially what I try to do in the event that a deal is about to go upside down or somebody's not paying is I always jump back in and try to be Switzerland in between the two parties, because normally they're going at each other. and try to bring cool heads back together. We try to work with a tenant or a buyer to help them generate additional cash so they can pay the seller and keep him whole, and everybody's happy, and he retains the house and the deal stays intact. And we actually did that with this particular buyer on this property. Well, in doing that, he got to learn all of the ins and outs of our contract. Okay. He understood equitable interest. He knew backwards and forwards because he was live with me on calls on other deals because he was an actual client that had been through it and could testify to the fact that, yes, we got him into a house and no, it was not a scam. And here's how the whole thing works. And so when he lost his job and the whole thing went upside down and he started playing I'm going to make you drag this thing out for an eviction, or he brought up the equitable interest argument in court on a lease option deal that was structured very similar to what yours were. We had the waiver in Georgia. I don't know if they have this in Ohio, but in Georgia, you can get a trial by jury for the eviction. We had that waived. We had all of his affirmative defenses waived. We had everything waived other than did you pay on time or did you not? And anything else must be brought up in a separate suit. And the judge upheld the contract. Okay. And I will be the first one to admit, as I have repeatedly, you do not ever want to walk into court, period, ever, because it's a roll of the dice. It's, and we've addressed this stuff. Congress doesn't make the law. The judge in the courtroom makes the law. That's who makes the law. And so anytime you can stay away from that, it's highly advisable. In this case, and we're fortunate, listen, we're rolling some of the same dice you are with some of these things to try to get a point across. And they may come back. They can strike out any line in here and say it's not enforceable. But that doesn't mean that we're not going to make the effort to present that argument that the buyer had that understanding up front, so that we can protect the security interest of the property and what we're doing here and get them out without having to take them through that. So that's that. And again, I'm not as familiar with Ohio law as you are.
Okay. It was part of what you were giving me a hard time about doing. So I've got to give it back to you.
That's fine. Listen, turnabout is fair play. That's why I want to do total transparency.
I find this a little bit odd, but we actually have a city here by me where the judge will not honor liquidated stipulated damages in a contract.
Yeah, and I agree with you on that. Basically the way I try to have the language in here, because in some states you can't get 18% interest. In some states you can't have, especially like on a lease option, they don't like the liquidated or specific damage. They don't like that stuff. And so what we've tried to do is we've tried to cover every possible scenario so that if one of the pieces of spaghetti doesn't stick, one of the other ones does.
One of the other things, though, is I didn't see in here and I forget the name of the clause right now, but like a separation clause that if one part of the contract is construed to be illegal, that they don't strike down the entire agreement.
And that should be in there if it's not. When you were rushing me the other afternoon, I was hurrying trying to get this thing together and redact it and all that, but that should be in there. You're correct. And if it's not, that's a mistake.
Okay. And just out of curiosity on the way these work, are you giving any type of rent credits to people or no?
Well, there's no rent credit because I'm not doing a lease agreement. The way these are structured is it's structured as an actual purchase where they would be purchasing the property. They're putting down a down payment that is a legitimate credit and applies directly against the principal balance. And then they make mortgage payments going forward that are structured as interest only and property taxes which is better than a rent credit, because if we're going to compare those two side by side, what happens is under a rent credit, you have a phantom paper credit that they may or may not get. And that is solely at the whim of whoever the lender is. Unfortunately, it's not like it used to be. And under this type of a scenario where you have mortgage payments that are classified as mortgage payments by the IRS that are legally tax deductible, what happens is if we take a W-2 employee as an example, like I told you, we were getting these people back to $8,000 on the first-time homebuyer tax credit. Under the tax, this is another reason we went to these contracts years ago, from a standpoint of being able to provide additional benefits that basically nobody else could or would at that point, is the monthly payments are tax deductible. They're structured as interest only and property taxes because under current IRS code, you can legally deduct the interest and property taxes on a primary and secondary residence on combined lien amounts up to $1.2 million. So I structure the payments as interest only. That maximizes the tax deduction for the buyer. it also adds additional padding for the seller for additional profit, because they're, in most cases, are still going to be getting amortization on the mortgage, the underlying mortgage that's actually being paid. So in addition to full fair market value or full price, as opposed to selling at a discount, they're also still getting the amortization over the contract term. And then what happens is, if we have a W-2 employee, then we will get them with their CPA or person from H&R Block and have them amend their W-4 in what the IRS calls the anticipation of the tax deductibility of the mortgage payment. And to give you an example of, here, if we take this contract, what's the price on this one? $750. So we take $750,000. Or wait a minute, let me back up. I think the payment was $5,000. If we take $5,000, person that can afford $5,000 is generally going to be, and Bill may argue with this, and if he does, that's fine, but they're generally going to be in probably the 35% tax bracket, I would guess, based on my experience. So if we do that, and obviously there's other factors that can be, because you can hit alternative minimum tax and all that, but under here, let me use a normal example. If we go like to say $3,000 a month. So what happens then is you get somebody in a 35% tax bracket that is making that payment, and through an amended W-4, they can realize that tax deduction on a monthly basis. And if they follow our instructions, what would happen is their net take-home pay, all things being equal, and I'm not talking about getting off on wild tangents of other tax scenarios, but all things being equal, a normal W-2 employee, they would increase their net take-home pay by $1,050 a month under that scenario. So they pay in $3,000, they get a net benefit in real cash, real spendable cash on a monthly basis of $1,050. So from our perspective, from a sales perspective, it's a much better scenario than a phantom rent credit they don't get until the backside, maybe, if the lender lets them have it. And number two, from a risk mitigation standpoint, what I want to do in these deals is, number one, we want to have deals that succeed. Number two, we want to, quite frankly, from a selfish perspective, I want to touch a deal one time. I don't want to have to get back involved later on because something goes upside down. And if I look at it from a seller's or a landlord's perspective, and if I can put together a structure that increases the cash flow and take-home pay of a buyer or borrower, what that does is helps insulate me as the seller from a default, because now we've increased their take-home pay, so there's less of a likelihood of them going upside down and defaulting. So there's multiple purposes for that, but that's the way that they're structured. Now, let me qualify this, because we have a lot of people that are listening to this, and we're going through a lot of different machinations here on how things are put together. You cannot do it this way under Dodd-Frank on an owner-financed mortgage. Now, let me rephrase that. Primary residence, owner-occupant. Okay, you cannot do it the way that we have it structured right here, because they will not allow for the interest only. They do not allow for the 24-month balloon that we have in here so that we can get the seller refinanced and taken out, et cetera. This structure, and this is the reason why we had every one of you agree to the non-disclosure agreement, non-dissemination, is a very proprietary methodology that intertwines a lot of different things here to put things together legally to maximize the benefit for all parties, my company, the buyer, the seller, so that it's a win-win all the way around. So, Bill, I don't know if you want to address any of the tax stuff since you're on. Can you? It looks like I've got you unmuted, but it looks like you may still be muted.
No, I'm here.
Okay, all right. So was that accurate, what I said on the tax stuff?
That was accurate on what you said with tax stuff. Absolutely.
Okay.
All right. Hey, Vince, this is Rob the House Guy again.
Hey, Rob.
Questions here. Hey.
Sure.
All right. The one, so if I heard you correctly, that this paperwork is designed for you to deal with a non-owner occupant, not an owner occupant?
No, I'm the non-owner occupant.
But you're selling to a owner occupant.
No, that's how we're avoiding Dodd-Frank. I'm not selling it to anybody. If you understand, like I said, and I'm not trying to be a wise guy or split hairs here, but you have to, if you've gone through and read Dodd-Frank and you understand all of the intricacies of that spider web of just literal crap that they put together.
Oh, I get it. Yeah.
Basically, what we've done here is let me back up. Their whole thing is predicated off, and Bill, jump in and correct me if anything I say is incorrect, but from my understanding, their whole thing is predicated off of the origination of a mortgage. Okay. So what we've done is we put it together so that we are outside Dodd-Frank from a non-owner occupied purchase standpoint. And that's why we have the seller lease back in place. So
I gotcha. So
the intent
it's
is
done as a non-owner occupant. It's done as that, and you're just assigning it over. So it was not originated for that end user. It was originated for an investor that was assigned. Correct?
Exactly. You got it.
I gotcha. I mean, again, I'm going to go back to your statement of staying out of court. That would be a great thing to stay out of court on, because if it walks like a duck and talks like a duck, they're going to hammer us.
Yeah, they can try to argue circumvention, but basically, because of dealer status and what we're doing, we've got too many deals that are doing like this to try to even argue the circumvention aspect.
No, that's a good. It's slick though. I like it. Now let me ask you on item 15 on the assignment, where the you there?
Yep, go ahead.
Where the seller allows the buyer to assign this contract for deed.
Mm-hmm.
When you have that assignment done, are you having the seller approve whom you're assigning it to, or you just have carte blanche to do whatever you want? You can assign it to whomever.
God bless you for asking that question. Okay. And this is a big bone of contention for me with all of these other lease option gurus and everybody else that I see, where basically what they've done is they've made the investor, you or Jared or Angelo, if he's acting in an investor capacity, or Bill, they've turned you guys into basically these puppets and property managers for the seller. And you have to go back and forth and get approval. And basically what they've done is they've created an agency agreement where you're acting in a realtor capacity or a licensed capacity, because everything that you have to do has to be with the secondary or third approval of the seller at each and every stage of the game. That is not the purpose of an option agreement. The purpose of an option agreement, if you're doing lease options, is to gain control of the property, so you never have to ask anybody their permission for anything ever again. It's the same exact thing here. I'm going in. This is the deal. This is what you're going to get. I have the right to assign. You don't have the right to question anything about anybody I'm putting in here, because ultimately the whole thing is going to come back on me anyway. And we basically lay out for them how we're underwriting the files up front, so they understand what the criteria is. And here's the argument and that's not an argument, but here is what I have proposed to people before that have told me, well, the seller wants to see the application, or they want to underwrite the deal or whatever. And so I would just simply go back to them and ask them, well, let me ask you a question. Is the seller a loan officer or a mortgage banker? No. Okay. Are they in any other capacity where they've ever had to underwrite a loan before for performance? No. Okay. So they've never been professionally trained on reading a credit report. They've never been professionally trained on underwriting a file. They don't know what the triggers are for default and what to watch out for. They're not familiar with what it's going to take an individual to qualify for conventional financing down the road. This is the least qualified person in the entire transaction to be dictating, and let me qualify this, dictating from a performance perspective, because that's really all they're concerned about is two things. It's the two Ds. Sellers don't want default and they don't want damage. Okay. So they're the least qualified person in the entire transaction to underwrite whether or not a buyer or optionee or tenant or whatever we're calling them is qualified for that particular transaction. Because as we showed with how I can legally, and I hate to even use the term manipulate, but legally correct the credit reports, okay, to the tune of 28 accounts eliminated in 69 days on a 191-point swing, there's no legitimacy to the credit reports by and large, okay? So if they want to predicate things off of a score, well, that score is easily manipulated, so what value does it have? It's not a guarantee or insurance policy of future payments, right? If I don't get, as an investor, if I look at a deal, if I don't get a guarantee or insurance policy against default or guarantee of future payments, it doesn't hold a whole lot of weight for me. And that's why we have a no credit qualifying program, because I don't really care about the past credit. What I want to know is, do they have the financial ability today, based on what we know, to get into the property, have skin in the game, and be in a position to do that takeout or refinance the mortgage into their own conventional financing. That's really what I'm looking for. We want good, solid, performing, straight up, clean, totally transparent deals all the way around. So I don't allow the sellers ever to approve or disapprove of anybody. And this goes back to, once again, the ability to close and the ability to take control of a transaction, just explain to the seller, this is the situation, here's how it is. Now, unfortunately, everybody doesn't have my background and can't go through all of that stuff with them, but that's what we teach and what we train. And that's why when people JV deals with me, if I have to jump in and explain that to somebody, I absolutely will, because otherwise what they do is they got you running around like a dog chasing his tail. So a guy goes out there and he contracts with the seller on these agreements, and then what? He goes and gets a buyer or a tenant on a lease option deal, and then he has to bring it back to the seller, and the seller says no. Right. And okay.
Well, Vince, I've never had that happen. I agree with you. I could sell around that all day, that they don't need to approve. I like to do it just for a layer of doing something as a cooperative deal, that we're working on this together. And I feel it may insulate me a little as the investor. I don't think it's going to a ton. I can see how you can sell around that. I don't think that'd be a big deal. But I do have a secondary question off of you talking about doing your joint venture deals.
Okay.
So describe one of your joint venture deals. Let's pretend you're going to do a joint venture with Rob the House Guy. I'm right here in Northeast Ohio, the hottest market in America right now. And you and I need to do a deal together.
Right.
How are we going to do this? What is my role in this? Am I doing it on your paperwork, under your name or in my name, or how does it work? Walk me through the transaction.
Well, it really depends on what type of deal that we're doing. Are we doing a rent-to-own deal? Are we doing a commercial deal? Are we doing short sales? It really depends on what we're doing. I've done
taking over payments. So I was going to say it's a lease option assignment, or for yours, a contract for deed assignment. Let's do that one, just because that's the paperwork we have in front of us.
Okay. Well, this is a big bone of contention that I get into with a lot of people too, who always want to talk about, having me, or I guess the better way to say it. You heard Chris Chico say this exact same thing on his webinar earlier today. People want to come in and say, okay, well, I don't have any money to pay you for coaching or pay for your course or pay for anything, but let's do a deal. And then once we've, joint ventured that deal, then I'll pay you the coaching or the subscription membership or whatever it is out of that. Yeah. And I have to explain to people all the time, the joint venture means exactly that. It is a joint venture. It is not me doing everything in the transaction. Okay. Yeah. And teaching you the business along the way and then paying you half. That is not a joint venture. Okay.
Okay.
All right. A joint venture is, I'll give you an example. We'll use Bill, who's on the line here. A joint venture would be where Bill has a property and I have a buyer, or vice versa, that we then cooperatively worked together to put that transaction to bed. Now, that can happen any number of ways. I've got a deal in New Jersey right now where we actually have a joint venture agreement with a seller on a property. It's actually a bona fide joint venture. That's actually what the document says. It is a joint venture agreement. It lays out the terms and who's in control and what the financial responsibilities are for expenses and how the proceeds of the transaction are dispersed upon successful completion of the project and all that. So we use that's why I have to try to tell people all the time. Full spectrum investor. I'm not this little one trick dog and pony show or one trick pony where all we do is lease options, or all we do is, and there's nothing wrong with that if that's what you want to do. But I'm looking at deals and I'm analyzing them and trying to determine what's the best way to structure this. In some situations, we're power of attorney. In some situations, where it's a joint venture agreement, like I indicated. But basically, a joint venture has both parties doing their side. Either you're handling the buyer or the seller, not a scenario where you give me a name and number and I got to call them and do the whole thing and then pay you half. That's a referral. It's not a joint venture deal.
I agree.
So let me ask you this.
Sure.
When you're doing, let's say, this joint venture with Bill,
Mm-hmm.
he had the property, you had the buyer.
Mm-hmm.
Did he get this contract for deed signed with the seller, or did you?
Am I the seller, or I have the property?
You have the buyer.
I have the buyer. Okay. Well, let me qualify this so that it'll make sense. Because you asked me a couple of different questions there, and you've seen this if you've been in the group for long. I just went at that guy. What's his name? His name escapes me off the top of my head, but he's the guy that came to me with Keith French's documents that were executed on a property. And I said, yeah, I'm not moving forward on that because, number one, you don't have control and I don't have any legal ability to be involved in that particular transaction. So if it's a scenario where I'm involved, I'm contracting on the property every single time. Okay. Or let me rephrase that. Unless we have some other joint venture agreement or a power of attorney, something else that gives me the legal and or equitable title to be involved in that transaction. So to get back to your point initially, which was how are you not illegally brokering without a license? I do not provide services related to buyers and sellers on a purchase transaction or otherwise for a fee. That is not what we're doing. So I would not be engaged in a deal where I don't have some type of get out of jail free card that ties me to equitable interest or power of attorney or something like that in a transaction. Now, I know a lot of guys do that, and you'll see that on these wholesale deals, and they put stuff all over Facebook, and I'm just like, good God, what are you doing? I would not put that information out there, quite frankly. But that's the way that I would do it. I don't go into these things half-cocked because I need to have a deal done so quickly that, we'll throw caution to the wind, because I know how that stuff, comes back. Ultimately, it all comes back on me. So I'd rather do it right up front with all parties so that everybody knows exactly what's going on and who the parties are, and that we have the legal ability to do what we're doing. And I've been accused of brokering without a license before, and I go back to them every single time. We've been through this stuff with builders. We've been through it with builders and their attorneys. We've been through it with attorneys as clients. I've had phone calls from attorneys general in numerous states. And the last one, as a matter of fact, is actually a guy that we did a deal with in here. I'll tell you what, you want to hear a deal that you guys would probably tell me you're going to go to jail for? I'll give you a deal. It's already been reviewed by the attorney general. It was a kind of deal that we put together and contracted on with a buyer subject to our acquisition. All right, it's all defined in the contract, exactly what the roles are, what everybody's supposed to do, et cetera. Got a waiver of liability, a hold harmless, and we had it documented 7 ways from Sunday as to what the deal was, so there was no out. And we have it all recorded with the buyer so that if we ever were dragged into court, that we had, all the prima facie evidence that proved that what we were saying was accurate and that he was making a knowingly false claim. Well, because of the waiver of liability and hold harmless agreements that we have in there, and the guy is another investor and he knows exactly what the deal is, he knew he could not sue us, that there was no grounds for a suit. So instead of doing that, he took the traditional routine. You guys have to be careful of this stuff because there's a lot of lunatics out there. He tries to take the internet defamation routine. And so he goes out and he makes a complaint with the Better Business Bureau. He gets a hold of the attorney general and they start contacting me. He then starts putting up all kinds of websites with knowingly fraudulent information on them, trying to, slander and defame us to try to harm the business. Well, I had to go through this stuff, backwards and forwards with the attorney general at that point in time. And I actually had the guy recorded. Matter of fact, I'll go back and pull the call up and we'll post it so you guys can actually hear it, where the attorney general tells me that he's read everything and he's like, I don't know what this guy's complaining about. Okay. So, and he has our contract, the exact same contract that you're looking at right here, with the exception of the fact that it didn't have the seller lease back in there because it was not that type of deal. And it was prior to Dodd-Frank being imposed. And it was on the acquisition of a foreclosure that we were moving forward with. So at any rate, yeah, we've been taken to task 7 ways from Sunday with about every entity and party, realtors association, you name it. And, Angelo, if you want to get into some of the other stuff, we can talk about how all that works, because I know you mentioned the current.
Go up 1 page to section number 9 with the equitable title.
Okay. All right.
And it says, and I don't understand how, your whole thing where it takes it out of Dodd-Frank is because you're an investor, and so Dodd-Frank doesn't apply. But if you look 4 lines down, it says it is agreed that said premises shall be used as a primary dwelling house only.
Right. It's a Scrivener's error, because that should have been. It's actually documented in here that it's non-owner occupied prior to that. That needs to be changed. You're correct, because this was the original owner occupant document that we modified. So yes, you got me on that. That is correct. That is supposed to be non-owner occupant dwelling house only for the purpose of this transaction until the point in time it's assigned.
I noticed on there that you had the earnest money or the deposit on this is $1 for the interest of the contract, correct?
$1 for good and valuable consideration to have a legal and binding contract. Yes.
Yes. I know that a lot of the law will say that. I've actually had the wonderful opportunity of talking with the Department of Real Estate for Ohio. Again, I don't know the entire nation, but I do know Ohio. Mm-hmm. And they were not cool with that at all, doing the $1, $10, $100. They wanted somebody that truly had something at risk in the deal, or they were pushing it as acting as a broker without a license. For me, that's what they were going after. So saying that if I can't find someone to assign it to, I'm still on the hook for the license, or for the payment, rather. I'm still on the hook for the payment. Have you ran across that in any of your states?
I have not. I know what you're saying, and let's see if we want to get into this. This is kind of where I was trying to get Angelo to go a minute ago. There is a thing that I call the stupid test, and the stupid test is given out by attorneys. It's given out by collection agencies. It's given out by governmental agencies. It's basically, it's given out by landlords. It's given out by, and basically, if you take a look at Angelo's lease option contract with the maintenance and repair clause, he's given somebody the stupid test right there to determine whether or not they're going to, pass or fail the test. And what happens in many cases is that you have some governmental entity that will tell you something that is not necessarily legally accurate. And that happens all the time. And it happens to people when they're being harassed by collectors. It happens to people when they're being harassed by attorneys who start doing the saber rattling, when they're threatening lawsuits and all that. It happens all the time. And these state agencies, part of the problem is that everybody cowers to them, and they feel like they've got some sort of governmental jurisdiction over them, and they simply do not. Okay. And you have to understand that. They apply the stupid test to investors all the time to determine whether or not you're going to fall for it and acquiesce to their nonsense, or whether or not you're going to come back and say, hey, wait a minute, time out. Your job is to govern and regulate licensed activities, not interfere with commerce. Okay. And that's what they end up doing most of the time. They don't have jurisdiction over non-licensees, even though they'd like to tell you that they do, unless you're engaging in licensed activities. And I do not engage in licensed activities, which is a service on a purchase or sale or potentially a rental for a fee. That is not what we're doing. They can try to argue it all they want to. As it relates back to what you mentioned a minute ago about the dollar down not being quote unquote skin in the game, my argument to that would be, if anybody ever brought it up, would be simply this. That's this. If I bought a $700,000 house in Atlanta that I did a custom build on, and I did a bazillion mortgages for all of my high income, high net worth clients that I had when I was in mortgage banking, that were all 100% financing, no money down. Okay. And now that a lot of that may have gone away, or all of it may have gone away since 2008, but that was standard practice up until that point in time. And if a bank didn't have an issue with it and the IRS didn't have an issue with it, and the IRS does not have any issue with applying the benefits associated with a purchase of a property on this document that you're looking at, I don't know how any state agency could legally argue that. They can argue whatever they want, but how they would have any teeth in their argument or be able to push forth a cause or an action based on that, because all of the other ruling authorities are going to disagree with that.
Okay. Well, I agree with you 100% in what you're saying, but I always try to live by the rule that I don't want to make an enemy of someone that has more money and resources than I do.
Sure.
So to fight that could bankrupt you. That's the only thing that bothers me. That's why I just find it a little bit easier to sometimes play by their rules, even though I think I'm right. I know that's what they want, but
yeah, no, I hear you. So I'm not. Let's back up. So what rule are you telling me that I'm not playing by that they want that you do it?
Again, for the state of Ohio, the sum of $1, and you really don't have any skin in the game, or you don't have any risk whatsoever, and them telling me what they can come in and do and the fines they can impose, I could probably fight the fines and appeal them and do everything else. But in the meantime, when you're having cease and desist letters coming in, and you cannot continue to operate your business that generates income, and now you have to start spending all your reserves to fight it, that just, I would rather just play by the rules a little more, I guess.
But who is the agency that's doing that and threatening that?
Oh, it's the Department of Real Estate in the state of Ohio. And it's not me. It's just everyone's had that come down on them. Yeah. The assignment of lease options and assignments of contract for deeds and things of that nature.
And what I would say at that point is that, first and foremost, there's no jurisdictional foundation that they have, number one. Nobody will ever contest that with them, though, because they don't even know to. Number two, there's no proof of claim. Who's the victim? This entity does not have an ability to come in and fine you. Who are they? Who gave them that right? There's no right they have to do that. No, they don't. They have that on licensees only who have subscribed and signed up for the permission to engage in a licensed activity for a fee. That's who they have the ability to legally regulate, not an individual investor. Now, does that mean, because it happened here in Arizona too last year, does that mean that they don't go after and target guys and do the exact same thing and hit them with also? Of course it does. But what happens is, and again, no offense, Angelo, but what these guys do is they go get an attorney. All right. And we've demonstrated here 7 ways from Sunday that the attorney, number one, does not work for the client. He has a bona fide conflict of interest with the client. He is an officer of the court first and foremost. And so he basically, does lockstep with whatever the court procedure and what the judge says and what they believe that the law says. And unfortunately, nobody tells these guys what the deal actually is. They're not familiar with, they have the right to have your accuser. Who's the accuser? Who is the victim and who is the accuser in that scenario where you're in the deal for $1 and you have a buyer and seller? I mean, unless somebody is saying that they have somehow been defrauded by you, which that's different. Now you have an accuser and you have a alleged victim. That's a different scenario. But the quote unquote state of whatever, or the quote unquote agency of whoever it is a private corporation that does not have jurisdiction over you as an individual unless you're licensed or unless you're actually, engaging in licensed activities for a fee and you're not licensed. Now you can argue that all day long. And I'm just telling you, I've been around with attorney generals before on all this stuff. And I hear exactly what you're saying, but the problem, you can lay down and continue to lay down all the way up to the point in time that, they've taken away your ability to do business, which is what they're trying to do now.
Right. Exactly. Yeah, maybe I'm just lazy. I want to just continue to do business and make money and not fight battles.
No, that's fine. I don't want to fight battles either. Okay. But at the same time, when somebody comes over and they want to start pointing fingers and say, if you don't, fall in line, we're going to knock you over the head with a club. Well, I'm not the right guy to say that to. Okay. Right. And it doesn't mean, you see, part of the problem here is this, and don't take this the wrong way, but the average individual has a defined need to go and retain an attorney because they have not educated themselves on how to act as a pro se litigant or a pro se defendant in any type of cause that's brought up like that. Okay. So that's basically what they end up doing is if you don't fall in the line then and do what we're telling you to do, then we're going to prosecute you. And in that case, now you're looking at, you got to drop $5,000 at a minimum with an attorney. Typically, most of the time it's going to be 10 for any type of thing like that with a governmental agency. And that's just to get them going. And now you're looking at 10 to 15 grand a month in attorney fees to defend whatever that action is. And most people look at that and they're just like, number one, I don't have it, I can't do it, et cetera. And it's not necessary because they could defend them, they could handle the things on their own if they would educate themselves, but they don't want to do that. And so that's how, again, it's almost like an urban myth thing. It's like, oh, well, this happened to so-and-so. Somebody told me this in Virginia. One of the guys from one of the groups said that somebody came after him in Virginia for doing something. And I'm like, well, what'd you do? Well, he went and got an attorney. What's the attorney do? Well, the attorney did what they always do. And they milked him dry and told him to, when there was no more money, well, you better do what they say. And I mean, who needs that kind of advice? That's not what you need. You know what I mean? So I hear you. And I mean, I'm knocking on wood. I'm knocking on wood right now. Asking Jonathan to pray for me. He's on here too, that I don't run into these scenarios anymore because I'm not looking for a battle either. We want to do good, honest, solid business legally as possible. But the fact remains this, and I had this conversation with Bill the other day, that the way the legal system is set up, Rob, I don't even know you, but I could sue you right now, and there's not a damn thing you can do to stop it, okay? So there's nothing preventing anybody or any entity at any point in time from, coming at you with a cause of action. That can always happen. And ideally what you do is, like you said, you tiptoe and dance around and keep your head down and try to fly under the radar as long as you can so that you can avoid all that stuff. But it's important to know that when that stuff does come up, the right and proper way to handle it. And, some of these guys out here have heard me say this before. My advice is not always to run to an attorney, or if you're going to go to an attorney, it's to qualify that attorney so you have an understanding of what their knowledge and their scope is. And that's not what, especially when you're dealing, if this is not meant to be offensive to Angelo, but especially when you're dealing with real estate attorneys. I wouldn't use a real estate attorney for a contract or a contract review unless he's a litigator, and most of them are not. Most of them are title attorneys. They write title policies and they handle signatory services for closings for banks. Most of them don't litigate, but they'll be happy to jump on LexisNexis or whatever it's called and pull down a form contract for you that they have no knowledge of, the inherent dangers associated with using that. And it's just like the standard, in Florida, they call it the FAR bar contract, or in Georgia, it's a GAR contract that the realtors use. Those things are a disaster, in my opinion. And I've seen people do that left and right. But supposedly they have 14 attorneys that are on the board that put all this stuff together. And it's this wonderful document that is ironclad and bulletproof and all this, but it doesn't work that way in practice. So yes, anybody can make a claim at any point in time. They can come. I've been at it with Attorney General before. A state agency can come say anything they want, but they get through a lot of that stuff because of fear more than anything else, in my opinion. That's what I call saber rattling when an attorney sends you a demand letter and notice he's going to sue you. And they do that to people because they're trained that way in law school. And the average individual, when they get that stuff, they panic. They've never been sued before. They don't know what the game is. They don't know how to play that game. And so they panic and they run out and get another attorney. It's like this feeding cycle that goes over and over again, as opposed to what I do when I get them. I just kind of look at them and laugh and say, okay, you thought you had somebody else here who didn't know how to do this, and that's fine. But then we're not going to play it that way. And once you pull their teeth out, it's a whole different ballgame when you're dealing with most attorneys, quite frankly.
All right. Going back to your contract, though, a couple other clauses.
Sure.
So figure we give these people some of what they were looking for. Do you give people time to review this stuff before you're
No, I do. I use, my name is Polisi, and I use the method that Nancy Pelosi uses, and we blindfold them and make them sign it, and then we give them keys.
Well, a lot of times people will show up at the house or talk to them, and they don't know what they're signing until the time comes.
They show up they don't know what they're signing until the time comes for what?
To sign the agreement. So let's say your investor who found this property goes out to meet these people.
Mm-hmm.
They end up just showing up at their door and saying, hey, here's the contract. Time to go over it. We're signing it now.
The contracts are 99% of the time, if you're talking about with the seller, they're emailed out via DocuSign. And so the seller has whatever time they need to review the document prior to executing it. And to give you an example of a deal that we're working on right now, the seller she's got about 30 properties between Pennsylvania and California, and has this document that you're looking at, and took it to her attorney in Pennsylvania, or sent it to him in Pennsylvania to review. And he came back, and there were 3 tweaks to the contract that he wanted. One was something related to Pennsylvania requiring an assignment fee that has to be paid, which I was not aware of. So I was glad that she came up with that. And the other 2 were just minor. I can't remember what they were, but they were minor tweaks to this agreement. So yeah, they have all the time in the world to review. I mean, there's nobody with a gun to their head requiring them to do anything.
Do you generally encourage people to get something signed?
Do I encourage people?
Or, do you get it reviewed?
Do I encourage them to get it reviewed by an attorney?
By an attorney.
Yeah, if they're concerned about something in the contract, absolutely I do that, because as you know, you're required by law to not engage in providing legal advice. I'll tell them what my opinion is, okay? But if they have concerns, they obviously need to consult with an attorney on that. And I'm happy. And as a matter of fact, if you've been through some of the stuff on some of the recorded calls that I have, where we're actually dealing with live sellers and with some of the objection handling that we use with sellers, you'll see and can read for yourself in black and white that when they bring up anything related to an attorney, I tell them right at that point, I'm happy to speak to your attorney. Why don't we go ahead and get him on the phone now? Now, there's a caveat to that as well, and that is this: if a seller is concerned about my document, okay, let's say that, okay, well, I want to have my attorney review your document. Here's what I would come back to them and say. I would say, Mr. Seller, I'm happy to do that, but let me provide you with some professional advice. I've been doing this a long time. I've retained, many attorneys over the years. And what I can tell you from personal experience is that you never, never, never pay an attorney to review somebody else's contract. And the reasons for that are as follows. Number one, you're basically, in most cases, backing him into a corner and leaving him with no choice but to come back and find something that's inaccurate in the contract. Okay. The other thing you have to be careful about is there are two different kinds of attorneys. There are deal maker attorneys and there are deal breaker attorneys. Unfortunately, most of them are deal breaker attorneys, just like most realtors are. And so what I advise them instead is say, listen, I'm not married to any contract. All I want to do is put together a good deal that is in legal compliance. So if anybody comes calling or knocking, I have a get out of jail free card. So I am happy to use any contract that your attorney is already comfortable with. That'll save you money. We can use his contract as long as it provides the provisions in the contract that I need so that I am not illegally brokering without a license, number one. And so that the end buyer in the deal has the rights associated with the property that they are supposed to, which basically is the right to quiet enjoyment and the right to force production of the deed at some point in time during the contract term. Beyond that, I really don't care if it's written on a cocktail napkin and who drafted it because it's immaterial to me. I'm not one of these guys, we have to use my contract. That's not my house. I'm not the one that has the, on the deals we've done, prior to this, it's not my home. I don't have the underlying mortgage. I don't have the risk associated with, we'll have to get into that here in a second with the insurance and all that, how that works. But I'm not the one that has the quote unquote risk associated with damage or default, even though we indemnify and insure against that stuff. And so it's imperative that a seller is comfortable. And if they have an issue where they have some concern with our contract, you can't do business, or maybe you do, or Angelo, I don't know. But my advice to people is flexibility in structuring a good deal as opposed to putting blinders on and always trying to force a square peg into a round hole. Now, Bill, what do you say to that? Would that not be what you would recommend, or do you have some standard boilerplate contract that you always use no matter what you want?
No, I do the same thing.
Yeah.
No, I do the same thing. Ordinarily, I usually end up using my contracts. The seller doesn't mind. I think in all the years I've been doing it, I've had one time when a seller already had a contract that he wanted to use, and we just did an addendum to the contract and put in some of the clauses that I wanted.
Yeah, perfect. That's exactly what I would do as well. The key thing is, again, I can't emphasize this enough, is staying in legal compliance so you don't have to worry about, whether or not somebody says you're brokering without a license, and to ensure that all parties are properly protected so you have a bona fide win-win. Otherwise, let me qualify that. Our contracts are egregious enough as they are. They provide the buyers with what they're supposed to be getting, which is right to occupy, quiet enjoyment, and the ability to force production of the deed, which is really the only things they're concerned about. But I've seen some fairly egregious contracts that sellers have provided us over the years where they've basically merged a purchase contract and a lease contract, and I'm like, well, yeah, but you can't really do that, and you can't limit who he's got here, and you can't do all these 27 things that are in a standard lease agreement on a transaction where there's a sale, because it's not going to hold up anyway. But at any rate, so next, what else you got?
That's about it for now. I was going to see if anyone has any questions.
Oh, come on, man. I thought we were going to take the gloves off and go at it. You're not giving the people their money's worth here, Angelo.
Listening for over an hour. Most of the provisions you've already told me that that had to be changed, or yes, that is what we did. Similar to you, that we're just for force, but we understand that it's not enforceable.
Yeah, to me, it's kind of a tomato thing. I think it's a different document with a lot of the same stuff that you'd have to argue in the court of law, and it's just a choice. What do you want? You want fries or onion rings? They're both the same. It's okay. It seems like it works. How many deals a year are you doing with this contract?
We've got 100 something, I think, on the website right now. I don't know what the total number is. I'd have to ask Stephen or Renee. But
What do you mean on the website?
the website that we market the properties on, of course.
So that's a whole question right there. So you're marketing the properties on the website, or are you marketing contracts on the website?
No, we're marketing the property on the website for sale.
Okay.
And these are the properties that you own.
Well,
or have an equitable interest in.
Exactly, correct. I don't have any deal. Let me back up for a second. I don't have any house. We don't do any deals on any properties where we don't have a contract that either provides legal equitable interest, and that can get sketchy sometimes because every state, they're constantly coming out with new laws and trying to say what is and what is not equitable interest.
Right.
So we have a provision in the agreements that say that if, it's basically the clause that you were referring to earlier, that if any portion of this is construed not to be in compliance with the state or federal agency that's, looking at it, that to convey equitable interest, that the seller or the optionor, depending on who it is, will help us perfect the document so that we may maintain legal compliance and maintain equitable interest on the property.
And I like that clause. Actually, I do remember another thing. When I was asking you if you encourage an attorney to review it,
have
you ever had someone come back and say that the contract's going to be construed against you because you're the one who drafted it? And so that's why you want to encourage them to actually have it reviewed?
I don't know that I have anybody say that.
Okay.
And I'm not saying that you're incorrect. I'm just saying I don't recall. Basically, I'm not sure who just said that. I think it was Rob just said this, Bill, that 99% of the time we use the document, or the seller is happy with the document that we have. I'm trying to think. I think maybe one time in the last 7 years we've actually had somebody come in with a contract that they wanted from their attorney, but there's no attempt to try to conceal anything from a seller or try to bum rush them into a contract. And I'm happy to review the entire thing with them, and I'm happy for them to review it with their attorney. I think from experience, I prefer it if they don't go review my contract with their attorney, just because it tends to kill the deal more times than it does to help promote a deal, because you run into what's called the not invented here syndrome. And so, again, not to bash Angelo, but my experience with attorneys by and large is that unless you get a deal maker, and they are out there, but unless you get a deal maker, what you're going to run into is the not invented here syndrome. I have to find something wrong with the contract because, they basically back me into a corner, or no, don't do the deal, because if I tell you to move forward with this, what's just happened is I, as the attorney, have now garnered liability because I told you to move forward with something that you can then come back on me and file bar complaints and, suits for errors and omissions and all kinds of stuff. And so for a lot of different reasons, they will quash the deal, as opposed to saying, well, I'm not happy with this, but, why don't we either change this, or here's my document, and see if they'll accept this. I've never understood that. Okay. And I just had this happen. We actually just had this exact same scenario happen on that deal in New Jersey with the joint venture agreement. And we've got that recorded. We're actually going to post that so everybody can hear it, where the seller comes back to me and says, yes, I had my attorney review the joint venture agreement, and he doesn't like it because there's a clause in here that is too vague. And so he told me not to sign it. And I was like, okay, not a problem. I mean, I don't have any issue with anything that he said, but did he provide you with the language that he would like that would make it clearer so that he was happy with it and would sign off? Or did he provide you with a joint venture agreement that he's happy and acceptable with that we can use again? Because once again, I'm not married to this contract. And the answer in both of those cases, and you can hear it live, is that the answer was no.
Okay. Let me ask you the next part of the question. It's a two-part question.
Sure.
And the word is conversion. You said you have 100 and some of these locked up in contract for deed right now. What is your conversion ratio from what you lock in the contract to what you assign? And then once you assign it, what is the conversion ratio of them actually going and getting a mortgage and completing the deal?
Well, you're kind of getting into some much deeper stuff here, and some of the stuff I've actually covered in some of the webinars that we've already done. But basically what happens is, and again, keep in mind now, this whole thing with Dodd-Frank just came out this year. So prior to that, the way I've addressed that, and I've said this repeatedly, even throughout the group, and so people can understand it, when you are in the, and we can ask Angelo the same exact question since he does these as well. When you contract on a property for a lease option, okay, where I don't know how you guys are doing it, and you have the property out there and you're marketing the property, my experience is that, quite frankly, 9 out of 10 people that call on that house don't actually want that house.
Right.
They want they triggered off the no credit qualifying aspect or the owner finance aspect or some other trigger made them call. And what they're trying to find out is if you can get them another home that is in their market area that matches what they're looking for. So I stopped building standing inventory for myself personally now, for my own deals back in 2008. And I went to a buyer first model at that point where instead of having to get, 10 houses under contract or 20 houses under contract to do one deal based on the buyer leads that you're generating, that then I could get a buyer, who'd come in and we most of the time only had to get one house under contract, and then we were closing on that and getting paid.
To me, let me pause real quick on that.
Yep.
Why do you have you told me you had 100 and some of these houses listed on a website.
Right.
Okay, where do they come from then? Are these buyers that just flaked out or something and didn't want it once you got it?
No. We're getting way off on tangents here, but the properties that you see on the website, the largest majority of them are properties that have been contracted on by my company, though, but they were brought in through our coaching clients and JV partners. And the purpose of that was to help them generate database of buyers themselves that they could then work with. Because unfortunately, what you'll find in these scenarios, like I said, is that 9 out of the 10 houses that are on there are not, or let me rephrase that, 9 out of 10 buyers that call in are not going to want that particular house. So the standing inventory thing kind of becomes somewhat of an exercise in futility in most cases, because unless you have a lot of penetration and density and market saturation in one particular market, where you can take a buyer who calls in on one and you already have 2 or 3 other houses that work for them, unless it's that scenario, a lot of these properties will never end up moving to an end buyer. Okay, and we understand that going into it. It's cost of doing business. You have to understand basically how the game is played with how the properties are marketed and all that, and how many buyers you're going to effectively have come in at any point in time. So they're utilized as lead generators for those who don't have buyers lists, who don't have the buyer first scenario, to bring those buyers in, because it is the bait that attracts the buyers, or the bait that attracts the fish to come in, because they're looking at properties, and that's how you bring them in.
So do you ever get sued by these sellers, basically saying you put a contract together for deed, you have this leaseback provision so that I'm not getting anything yet, you put $1 into it, and it's been a year?
The answer to that, Angelo, is no, and the reason why is because Dodd-Frank just came out in January of 2014. So not that can't happen, but there has not been enough time yet for that to even be a concern.
Okay, and more of the substance over form then. If you got a website with 100 different properties on it, even if you have equitable interest in all of it, they're going to say substance over form. You're really acting as a realtor. You have your own database over here. You have no intention of buying any of these things.
But I already have.
For the $1?
Well, it's the $1 really isn't a purchase. It's not a purchase price. That's to have a good and valuable consideration, which is required to have a legal and binding contract.
I understand that the way your agreement works, and that you do have an equitable interest. And if you have 1 or 2, but if you have 100 of them, and an attorney general comes and says, "Listen, I understand that you have an equitable interest, and you believe that you're selling the equitable interest, but we have the argument that substance over form. Your form may say that you have an equitable interest, and you're really just assigning your interest in this contract, but essentially you're acting as a realtor because you never perform on any of these unless you're assigning them. You don't have any risk at them in any of these things until they're at any point."
Well, whoever dictated that risk was a requirement to buy or sell or own houses, I don't know where that keeps coming from.
That's what the Secretary of State is saying here. For
In
people
Ohio.
who are, what's that?
In Ohio.
In Ohio.
Right. And are they the ones that just came out too and said that wholesaling and assigning contracts is illegal?
They didn't say it was illegal. They just said, don't go with any gurus, be warned of everything, and we're coming after you.
Right. The stupid test. using fear tactics. Yeah. So, I mean, again, we can get into semantics and split hairs until the cows come home. At the end of the day, on paper, documented, and we have gone through the steps in the process to do deals legally by obtaining legal equitable interest, and through the recordation, it could be argued legal title, okay? And again, argued. I'm not saying that's what it is because we don't have the deed yet, but in some cases we do have the deed. But if that's the case, then yes, then I would throw that right back on you, Angelo, and say, okay, you're representing or doing contracts for Joe McCall, who has half a dozen of these websites with properties on them as well. So what would you say the argument is there, where all he has is an option agreement?
I haven't seen his site, but I know he has a realtor's license.
Okay, but that's he only just recently got that, and that's only for Missouri.
True,
okay.
But I haven't seen his site. I don't know what's on there.
Okay, he's got a one in San Diego as well, where he's not a realtor. So at any rate, okay. So yes, could they come and say that? Absolutely they could. But at the end of the day, the documentation is here, and they're going to have to, number one, have to try to pierce through all of what we actually have here, which is a bona fide sale as far as the IRS is concerned.
All right.
It's a sale as far as the court or the clerk of the court is concerned when they record it. So essentially what you have, it sounds like, is a rogue agency that is going out trying to prosecute victimless crimes under the auspices of brokering without a license when I'm not collecting any fee.
I'm agreeing with you. I'm just telling you what they're doing.
No, I agree with you that that's what they're doing. I concur. But I'm just saying that there's a reason that stuff goes on and takes place.
If you're on a joint venture with someone and you're in Ohio and the Secretary of State or the Attorney General is coming after them,
mm-hmm.
You're interceding and you're basically acting on their behalf.
Say that, I'm sorry, one more time. If what now?
Let's say that you were doing a joint venture with me and the Attorney General comes in. I'm not an attorney. Your name is on the paperwork, so you're going to be the one who's going to be defending this to them? And I don't have to worry, or no?
All right. You're asking me if you and I do a deal the way that we're doing them?
Yeah.
Yeah. It's set up that way on purpose because you got to understand something, okay? And this is my issue with the rest of these clowns that are out there, these gurus selling all these courses and all that stuff. What they do, and if we're going to call a spade, let me just say it. You heard from it last week. What they do is they take and slap together these things that look like legitimate contracts. They put them up on a website for people to download. Lisa goes and does that and signs the deal. Now all of a sudden she's mixed up and embroiled in litigation that she can't get an attorney to defend her on because it's such a mangled mess of just crap. And then there's no liability or responsibility on the part of the party that sold it to her, knowing that there is fraud in the inducement because I have expressed it to him repeatedly in writing and on the phone that what they're doing is illegal and you cannot do that. And they have no liability. And so there's no recourse or repercussion. And what they do at worst is if you fuss loud enough, they'll give you a refund. Okay? I don't do it that way, man. I'm about as straight up as I get. It's my name on the contract. It's my company on the contract, not my joint venture guys, because they're new. In most cases, they don't have the experience. They don't have my experience. They don't have your experience. They don't have Bill's experience. They have no idea what it is, what kind of a buzzsaw they're walking into. And so because I don't want them to have that liability and end up in court, I say, okay, fine. You're going to come in and you're going to pay me for coaching, or you're going to pay me for a course, or we're going to do a joint venture deal together. Great. I'm going to be the shield up front. Okay. Because if that stuff comes at me, I know how to handle it. And I assume the liability on those transactions, not you as the JV who is either new to real estate or has done a couple of deals or did some wholesale and has never been in litigation, has never been sued, has never sued anybody, has never had conversations with attorney general, has never, been brought before boards and all this other crazy stuff that happens. You talk about bordering on the criminal, and that's what these guys are doing. They're putting people out there in those positions and allowing them to go off, and it's like giving a chimpanzee a machine gun, man. I mean, a lot of people are going to get bloody in those things, but the guy that made all the money, he's long gone and shown us photographs of his Rolls Royce.
Okay, but hold on a second. Let's pretend I'm not Rob the House Guy. I haven't done 1,000 deals here in Cleveland, and I'm just a new guy, and I want to bring you in, Vince. So what I'm going to do is you're going to come to Cleveland, and let's say I say, here's a cool house for you to lock up in contract, get equitable interest on. So we're doing it under your we're doing this under your LLC, and I have no interest in that LLC. My name is not on the contract, but I'm going to go out there and I'm going to market this house for you to find a buyer. Correct. And we're going to split the money up through our side joint venture agreement. Is that what you're telling me?
No, everything runs through my company.
It runs through your company. I understand that. But me, as just Rob, out here, I'm not Rob the House Guy. I'm Rob Gillespie, and I'm just out here now marketing a house that's locked up under your company name, and I'm not a W-2 employee of that company, nor am I an equitable interest holder in your company. Now I'm putting myself out there and having exposure to acting like an agent or a broker without a license. Well,
I understand what you're saying, but not the way that we're set up, because you wouldn't be marketing any property.
So what's my thing then if I'm bringing a property to you and you're putting it in your name and I'm not marketing to find a buyer, how am I really a partner then? What am I doing?
Well, you would be working with buyers that were generated from the marketing. That's your role in the joint venture transaction.
Right, I'm working with buyers to sell a house that I have zero interest in. You have the interest in it. I don't have an interest in it.
Yeah, but through a joint venture agreement, that doesn't prohibit you from doing that, because we have the equitable interest in the property.
Yeah, but I'm not a W-2 employee, nor do I have interest in your LLC or whatever corporation you may be using it. Okay. And I can tell you the Ohio Department of Real Estate, I know you're not a fan of them, they will hammer me. And if it walks like a duck and talks like a duck, you're basically making me an agent. I'm acting like an agent without a broker in Ohio. I don't know the rest of the other states, but in Ohio, that's how it's going to be looked at.
Okay, and what fee are you getting?
Well, I'm assuming I'm going to make money on this.
Okay, but yeah,
I'm not doing it for the practice.
No, I understand that. And I'm trying to play this out with you so it will make sense, because.
Okay, you have a house, and let's just say it's the contract for deed,
right? And
we're trying to assign that for $10,000, let's say, and you're going to give me $5,000 of that assignment fee. And I found you the house, you locked it all up in your name, and we have a joint venture agreement, and then I'm going through your list of buyers, maybe some of my own buyers or whatever, and trying to put them into that house and show it to them. Since you're in Scottsdale, Arizona, you're probably not showing the house. So I'm showing this house. Man, that's looking a lot like me acting like an agent.
Okay, well, I don't do any of those things, though, but go ahead. Bill?
The joint venture agreement is what would protect you, Rob. That makes you a part of that deal. You're not out there by yourself. A joint venture agreement would cover that. At least it does in all the states that I've done joint ventures with my students.
Well, I was in Ohio. What I'm familiar with is if I'm going to market a property, I have to have equitable interest. I can have a interest in the LLC that holds it, or I have to be a W-2 employee, not a 1099, but a W-2 employee of that company to actually do anything to ride on that equitable interest. I'm in Tennessee,
all right, but in Tennessee, North Carolina, South Carolina, places that I've done business, I have students who have a joint venture agreement signed with me. They don't have a part of my LLC, but the joint venture is looked at like a partnership. So that gives them that interest.
Well, I think at the end of the day, all of us are okay with everything we're doing until it gets under a microscope.
Right. And you were saying what gave you the interest and kept you from working as an agent. The partnership of the joint venture is what would give you that in the states that I've worked in. May not in Ohio, okay, but it has in the states that I've worked in.
Right. And I would agree. I would try the same thing, but I just wouldn't want it to be looked at very closely.
Well, and you know what? At the end of the day, any court, any court around could say, oh, that's not a partnership, and not recognize any partnerships if they wanted to.
Right.
But a general partnership agreement allows you to partner in with anybody that you want to partner with, and you can split profits with them. It doesn't make any difference if the property is in the name of one of the partners and not the other partner, as long as there is a partnership agreement or a joint venture agreement that covers that particular property.
Not sure if I would agree with that.
Well, I mean, you may not. That's entirely okay. But that's my story, and I'm sticking to it, and it's worked here.
I would say if you have a partnership with someone, the partnership should be on the contract, not just one guy or the other.
Doesn't have to be.
Yeah, I mean, let's back up for a second. Hold on. We're getting into semantics here. There is a difference between a partnership and a joint venture agreement.
And that's true too.
Yes. Yeah.
So
everything about contracts and legal is about semantics, though.
Oh, and that's the reason I keep bringing that up. So, and anyway, Rob, I understand what you're saying. We're not showing I don't know if you've been on the website or anything, but I do virtual investing all over the United States. I don't see houses. I don't go to houses. I don't attend showings. I don't attend closings. I don't do any of that stuff. Nor do I suggest that anybody that works with me or does coaching or any of that stuff do it either, because it simply is not necessary. So all of those activities that are generally considered to be licensed activities by a realtor showing a house, all those types of things, it's not something that we engage in, because most of the time they're doing deals. I would say 99% of the time they're doing deals in a state other than where they actually live. So they couldn't engage in that anyway. It's a phone conversation in most cases. So
right.
The sellers are either the sellers show the property, or there's a lockbox code placed, and once they've been through our process and been underwritten, then we'll give them the code and then go take a look at it and see if it works. But I guess my question would be, with what you just said, if you're the lease option guy and you're doing that, how are you not impacted by what you just said?
Oh, I am. I'm not saying I'm not.
Okay.
I'm just saying that you and I are about the same. We're doing the same stuff. You might have a couple different words in your contract, but neither one of us are protected anymore. I don't believe. I think either one of us under a microscope, we have to spend a lot of money defending what we do. I think I'm right, you think you're right, and I think you're right too. But it doesn't matter what we think. It matters what a government agency thinks and how much staying power we have to fight it.
Well, that's why I like to fight pro se, so I don't have to worry about staying power personally, because I don't have the expense associated with it. But and I agree with that. I think where I would take issue, quite frankly, with that is, and you weren't party to the webinar we did last week with Angelo, but my argument against that would be, your lease option agreements are disguised sales. You are conveying equitable interest. The intent is for the tenant. Excuse me one second. Pardon me. The intent is for the tenant to, as Angelo indicated, to believe that they're moving into the capacity of a buyer and act as such as they take care of maintenance and repairs. So for all intents and purposes, the intent of the entire agreement is it's an actual sale. So you have a de facto or disguised sale. And if you're going to get under a microscope, that would be the document that I would be concerned more about getting under a microscope, because everything in that document screams of a sale. Okay. And the case that, and I'm not saying you're doing anything wrong. I'm just telling you that's my opinion. I believe that's Bill's opinion. Scott was on last week saying how he'd been prosecuted on lease options for what we're talking about. In my opinion, what we are doing here is doing everything we can to do everything as above board as possible. But while we're talking about that, okay, because I've gone in here and we're not disguising sales. It is a sale. Here it is. It's a bona fide sale. The IRS recognizes it as a sale. It's a mortgage payment. All the terminology is in keeping with, other than the thing where I missed about the primary residence. And that's my fault, because I was trying to put this together really quickly for Angelo the other night, so we had time to review it, and I missed that. But beyond that, everything that we're doing here is we're trying to come out across the table up front and say, hey, look, this is a sale right now. Okay, there's no ifs, ands, or buts. It's a sale. This is what we're doing above board. So I don't have that issue of, okay, well, you're trying to conceal a sale out of the gate. I want everybody to know that it's a sale, be in agreement that it's a sale. The IRS agrees that it's a sale, and they convey the benefits to the tax of the tax deductions and any other tax related benefits to the buyer in the transaction. So that would be my argument against the lease option versus contract for deed, is that I don't have to worry about accusations of a disguised sale. Now somebody can come out and, like you said, they can try to claim that you're brokering without a license, but I'm not engaging in licensed activities. They can try to say that I am as much as they want to, but that's not what we're doing. And in most cases, like I said, they don't have any type of jurisdictional claim over what we're doing anyway. They think they do, and they get away with it because of the saber rattling and chest pounding stuff, and the fact that most people are too afraid to fight back because of the financial ramifications that you indicated. But what I would say is that in these scenarios, I like to be as upfront, totally transparent. Everybody knows what's going on. There's no shenanigans, funny business. We're not trying to conceal anything or circumvention and all this, all these other things that get involved, so that you don't have to worry about those things. You go out there and do good, honest business. But let's talk about that for a second, okay? Because realtors do business every day, and they're quote unquote licensed, and they are some of the least educated people as it relates to real estate and contract law that you will ever come across, because they have been commoditized and relegated into basically, non-fiduciaries, where their sole function, they're prohibited from providing any legal advice, even though prohibited from providing advice of any kind, according to the National Association of Realtors, because they have come out and construed that as the illegal practice of law without a license, but they do it anyway. And they've been kind of relegated down to a fill in the blank form preparer in most cases. Okay. Now, having said that, there are errors and all kinds of omissions and issues in contracts that are state approved by the licensing agencies that can be brought as actions in court against those parties as well, because I've seen it and we've done it. And that's, so the point I'm trying to make, I guess, is that, we can argue that, okay, lease option or contract for deed, or, oh, you got to be licensed, but even being licensed is not, it's not the insurance policy against any type of issue or claim from any state or governmental agency or other entity in any type of litigation action. It's a big misnomer. It's just like the thing with attorneys, man. It's like, because you have a license, what does that mean? I had a license. I had a real estate salesperson and mortgage broker licenses in Florida. And the very first thing they tell you when you get down there to the test that you paid $350 for the course is, we're not here to teach you real estate. This is the licensing course. Now, this is the course where you're supposed to learn all this stuff before they set you loose on the paying public. We're not here to teach you real estate. We're not here to teach you real estate law. We're not here to teach you how to make money in real estate. We are here to teach you how to pass the test. Okay? That is what they teach you in the real estate licensing course. And I've never had anybody come back to me and say, no, that's not accurate. It happened to me in the real estate licensing course. It also happened to me in the mortgage broker course I took. And the guy that gave the course, I took it at Stetson University, was a PhD in real estate. He was also an investor. He had all of his own cash flowing properties. He was also a mortgage banker himself, licensed, knew everything backwards and forwards. And he's in there teaching these people something. And I had to raise my hand because, I'm listening to this stuff and we're making money hand over fist. And some of these people are brand new. And some of the stuff that he was telling them was technically and legally inaccurate. And I had to raise my hand and say, listen, I'm not trying to, be the wise guy in the class, but what you just told them is not correct. And the guy looks at me and he says, Vincent, I totally agree with you. Okay, you're absolutely right. But this is the answer they're looking for on the test. Okay, so what happens then in the general sense is that they then get licensed. They go to their broker, who they've been told now is going to teach them the business. And any broker worth his salt is working with his producers, not with the new guy that is going to, wear him out and not make him any money for God only knows how long, if ever. And so they kind of get cast aside. And that's why you have, the average income for a realtor is between $45,000 and $60,000 a year. They are not experts on anything 9 times out of 10. That's not to say that all of them are not that way. I had a fantastic realtor in Sarasota. He also, in a prior life, had been an attorney for Merrill Lynch. And the guy was absolutely fantastic. I'd love working with the guy because he was a professional and he understood business. He knew the law. He knew his craft. Okay. He didn't just go get a license and say it's payday, which is what most of them do. So The point of this entire escapade that we're on here for all of the people that are listening is simply this. Ultimately, at the end of the day, it doesn't matter what Angelo the attorney says. It doesn't matter what Vincent the renegade says. It doesn't matter what Bill the CPA says. When your name goes on the bottom of that contract and you're engaging in whatever this activity is that you're doing, however you're classifying it, ultimately, you are the one that's responsible. So, as I say ad nauseum, vet everything. Don't believe anything I or anybody else tell you. Do your own due diligence, because ultimately you're the one that's going to be held responsible. Okay? I don't know how to give you any better advice than that. Now, we can argue, and Rob and I can go back and forth on this and have this conversation, because ultimately at the end of the day, every day that you get up and you're engaged in business, you're rolling the dice and you have no way of knowing what somebody is going to try to pull or what they're going to try to claim. All right. And so what you do in business, and my advice on this is, after you've done your due diligence and vetted everything, is instead of worrying, because I get a lot of people that, oh, I'm worried about this. And Dustin said it earlier today. He was worried about, all these things that we're talking about. And that's why we're doing this webinar. I'm worried about this. I'm worried about the contract. I'm worried about all these other things. And as a result, he engages in analysis paralysis and takes no action and does nothing to make no money. And that is what you cannot allow to have happen. It is a calculated risk, as we talked about last week. It is a calculated risk to this. You could have a realtor involved and you still have a calculated risk. If I have Bill go do my taxes, it is still a calculated risk, because the IRS can come back and say whatever they want. Okay, that doesn't change the fact that Bill acted in good faith and he knows what he's talking about. So don't let a lot of this stuff, and again, I don't mean to get on my sandbox here, but I would not allow the analysis paralysis and fear factor to stop you from doing business and making a living, provided that you have educated yourself, you have vetted whatever process or methodology it is that you're employing, and you've done your due diligence. Okay, so that you know, and you have the answers in the event that the quote unquote worst possible scenario happens. That would be my advice. Bill, what would your advice be to people that are out there based on these conversations? Because some of them may not have any idea which way to turn after these things. They say, oh, okay, well, the attorney said this, but Vincent said that, and who do I believe and all that. What would you tell somebody?
I would tell them exactly what you just said. Yeah, I mean, I think lease options have their place. Contracts for deeds have their place. It doesn't matter which one you choose to use. There are inherent risk in each one.
Couldn't agree with you more.
Yep. There are inherent risk in each one. Each one has a particular situation, which one is better than the other, I think, for different types of transactions. But like we've all said, okay, we found some of the same problems with lease options that we looked at last week with Angelo. Some of the same things with contract for deed. This time, it's just a matter of which contract is going to fit your potential set of circumstances the best. But I think all of them have to be vetted. I think all of them have to be looked at, and I think we should all be trying to do our due diligence and then do our transactions legally and ethically and morally.
I couldn't agree with you more. Angelo, what would you say?
I agree with everything you said. You got to do what's right, and at the end of the day, if you're standing behind your contracts, I like the fact that your name's on them for most of your joint ventures, so people aren't left out there. But I'd like to hear about when maybe a year from now, when these sellers come back and say, "I signed this agreement," and you have this leaseback provision. See what happens. Very curious to see how that'll play out later.
Well, yeah, and you know what? And it may blow up in my face. I can't say that it won't, but I don't anticipate that that's going to be the case based on the relationships that we build with the clients that we work with. But you could be right. You could be absolutely right. I have it set up that way so that it achieves what we're trying to achieve without me having to go into deep pockets on every single deal. Without any knowledge that we're going to be able to sell that particular property. So, but. Right. Yep, you're correct. It could explode.
I agree. Same thing. I agree. Just be ethical, honest, full transparency with lots of disclosure. Disclose everything that's happening, and I think that'll go a long ways if it's ever looked at.
Yeah, well, and I don't think, unfortunately, this is my fault. But he's familiar with the standard waiver of liability and hold harmless agreement. I have on every transaction I do, buyer or seller, they're both signing a waiver of liability and a hold harmless agreement as it relates to me in the transaction. And if anybody doesn't want to execute that agreement, then I don't do the deal. We're going to walk, because what I want to do on a transaction is I want everything out in the open up front. And I want to say, Mr. Buyer or Mr. Seller, if you feel like there's going to be some potential for an issue or cause of concern that you're going to have at some point in time later down the road, the time to address that is now. Okay. So bear with me here. So what I would prefer is that if you're going to have that concern, that we go ahead and get that out of the way now, so that whatever your concern is it's eliminated or mitigated at this point in time, because I'm not going to be on the hook for these things, down the road. I don't see the houses. I don't go to the properties. It's not necessary for what we're doing. And I'm certainly not going to guarantee anything as it relates to the house or the condition or whatever, because that's the buyer's responsibility. I mean, it's, caveat emptor, let the buyer beware. So they're not waiving, but they're agreeing up front that they've been advised to get a home inspection. They've been advised to talk to an attorney. They've been advised to get a home warranty, all of those things up front when they execute the agreement, and the lead disclosures and all lead paint disclosures and all that stuff, so that I have that get out of jail free card in the event that anything does go upside down, because I want that stuff gone. I want all of that inherent risk out of the way day one. Okay. And it is a phenomenal catalyst to vet out, or let me wrong word, to flush out any potential issues that are going to come up down the road. And I have to be honest with you, I've never had anybody balk at it. I've had to explain it a few times as to why they're executing. I just go back to them and say, listen, you've had an opportunity to see the property, or you've had an opportunity to, we have a buyer that's lined up and they're going to be paying, and you either want it or you don't. If you do, that's fantastic, but this is what I'm getting out of it. And I'm not going to be, staying up at night worrying about whether or not you're coming after me in court for something I didn't do, because I'm telling you the truth about everything right now up front. Okay. So that's the reason I have it set up that way. And, again, knock on wood, there's a reason I haven't been dragged into court on any of these documents at any point in time. That's part of it. It goes back to Angelo's, let's go ahead and whack them over the head right now and let them know what the deal is, so that we don't have to worry about it, later on down the road. And in his case, they're paying for maintenance and repairs. And in my case, I'm not having to worry about lawsuits. So that's why I do it. And if you're concerned about litigation, that's why, I'm not aware of anything else that you have to get. Angelo, if somebody's got a waiver of liability and a hold harmless, how somebody other than, legitimate documented fraud, how is somebody going to pierce the corporate veil and or go after them?
They're going to say that they trusted you. You told them that the attorney is just going to pierce through something, so it'll look like you appeared to tell them not to get counsel, and because they didn't get counsel, they're going to construe everything against you, and they're going to say they weren't properly informed in order to waive their rights and to sign this agreement, and so the judge will just throw it out.
Okay.
Worst case scenario, I doubt it'll happen, but
right.
Worst case scenario, I could see a judge doing that if all of a sudden he doesn't like you.
Okay. And let's talk about that. Let's talk about that for a second if it did, because that's really why these people are on this webinar, because it's out of fear in most cases, because they want to know how to have these things not happen to them. If that were to be the case, then the next step would be, okay, so you get rid of my waiver of liability and hold harmless, and whoever it is, buyer or seller, then has the ability to come and initiate litigation. Now I still have a corporation as a corporate veil in place. They're going to have to prove fraud to pierce it, to come after my personal assets, which I don't have any anyway. But at that point, that still doesn't guarantee them any type of win in court, strictly because they could get that document out of the way. It just means we're going to court at that point. So, and I think, with the provisions that I've got in here, that we've done everything we can up front to document as totally transparent as we possibly can what the intent was, what everybody's understanding was. And, then I've got backups of, and you have to be in the correct state to be able to do this or have acknowledgement, but I've got telephonic recording of every buyer and seller on every deal that we do, so that if anybody ever does decide to drag me into court, that we've got it all what everybody's true understanding was, if that makes any sense. So there's not going to be any wiggle room or anybody getting out of it at that point because of a document. And it's set up that way on purpose, just because I'm here to do good business. Okay. I'm not here to hurt people. I'm here to help people. I'm here to pay sellers. I'm here to help buyers become homeowners in an environment where the government is doing everything they can to prevent it. And at the same time, because I know I've got clean hands and I'm not doing fraudulent deals and we're not trying to hurt anybody, I don't want a lot of lashback on the backside, because what happens then, and let's here, you know what, Angelo, here, I'll give you free reign. Here we go. What happens then in most cases is if you don't have those provisions in place, then you get a buyer or seller that gets torqued one day, and maybe they're mad at you and maybe they're not, but they get mad about something. And then they go talk to Angelo, who's a real estate attorney, and Angelo takes a look at your contract, and Angelo starts going point by point on all the different ways that despite what they agreed to, they can sue you and they can extract money out. Okay. And that's what typically happens when you hear about these nightmare scenarios of an investor or a landlord or a tenant or something. So that's normally what would end up happening is they end up getting, an ambulance chaser to point out 27 items they can then prosecute them for, whether it's legitimate or not. And for those of you who've never been sued, let me explain to you how that process works if you're worried about a lawsuit. And then Angelo and Bill can certainly interject. But here's what attorneys do when they sue you. Generally, what happens normally out of the gate is you get what's called a demand letter. And this is what I call the saber rattling. This is where they threaten you with 27 things under the sun, and they try to provide you with information that is accurate, that looks condemning against you and what you did. Okay. And this is really to kind of beat their chest and play the stupid test with you, get you to acquiesce with what they want and stroke a check. That's normally the way it works with a demand letter. Then if it ends up in a full-blown suit, the way a lawsuit is drafted, even though this is illegal, okay, it is absolutely illegal. Attorneys do it every single day. They will do the spaghetti routine. And that's, we're going to throw enough spaghetti against the wall here to see what sticks, even if they know that the claim that they're making is knowingly fraudulent. Okay. And I mean, I've got lawsuits where I've been sued. I can show you that. I was like, these guys, they knew that what they were saying was not accurate, but what they were trying to do, it's all strategy, as Angelo would say, was you layer enough complaints against somebody that it's okay if you don't hit complaint 1, 2, 3, or 4. But if number 5 sticks, that's all you need is that one, whether it's legitimate or not.
If you file 10 claims against someone, and let's say 6 of them are not even, you have any way of saying that it might be a claim,
right,
the judge is going to be pissed off at you, throw the things out, and you lose any credibility there. So most attorneys have at least a way of claiming to say, you know what, this probably won't stick, but it's very possible that this is what happened. They don't really go out on a limb that completely has absolutely no basis. And if you do, you should start suing them for sanctions.
Do we want to go down that path? Because I've done that. I can tell you how that circus goes. But basically, what you're talking about is malicious prosecution, where they're coming after you for knowingly fraudulent claims. And hey, I'm going to argue with you because I've got it in documents. At least it's happened to me. I don't know if it's happened to anybody else, but where they threw all kinds of stuff, they knew it was not accurate. They had the documentation that proved that what they were saying was not accurate, but they went ahead and put it in there anyway to see if they could get it to stick. And I agree with you that a judge, if he were to get eventually he's going to get to the point where the information is going to come out in court to get rid of that claim at some point in time. But for the average person who's never been through a lawsuit, that's many sleepless nights and tens of thousands of dollars before that ever happens, as they're developing ulcers and having to sell all their stuff off to keep, fighting off the suit. And so at any rate, that's normally the way that process would go. Now, you talk about getting into the situations with attorneys and all that stuff. I mean, that's a circus because, number one, you got to find an attorney. If you don't know how to prosecute them yourself, you got to find an attorney that'll go against another attorney. And because they're all bar certified attorneys, all members of the same exact club, good luck with that, because I've yet to been able to accomplish that one myself personally, even with documented conflicts of interest and fraud and everything else on the part of an attorney and another person that was involved in something where they knew each other, but it was never disclosed. They'd been to each other's houses and had, been to barbecues and drank beer and all this kind of stuff. And we don't find this out until, we're knee deep in the whole thing. And it's that kind of stuff happens. So at any rate, we're going to way off on a tangent here. The key thing for the listeners is simply this: do your due diligence, vet everything, determine what feels good to you, and just understand that ultimately at the end of the day, you've got liability. Doesn't matter if it's my contract. There's no such thing as a boilerplate contract. Okay. Or excuse me, a ironclad contract. Not mine, not Angelo's, not Bill's, not anybody's. And that's the way that the court system is set up. Anybody can bring a claim at any point in time for anything. Okay. So what you want to do is ideally have as many of those claims negated as humanly possible up front, and do good, solid business. But even doing good, solid, honest business and being lily white and straight laced and, as clean as Bill feels like he is to me, that does not stop some lunatic who gets upset from coming after you. So it's just part of it. Okay. And if you can't handle that, then go be an employee. That still doesn't stop you from getting sued, but you can go be an employee for somebody else and think that you're avoiding that risk, but that's not really necessarily the case. Every time you step outside your front door, you've got risk for liability, whether you think you do or not. And if you ever go through any kind of asset protection education or training, you'll understand exactly what that is. But at any rate, all right. Does anybody have any questions? If you do, over here on the right-hand side, hit them with us so we can get those answered for you. And then we're going to kind of go along here, and then we can get this thing wrapped up. Kenneth Carroll, if the glove doesn't fit, you must acquit. Anybody have questions? Did everybody fall asleep? Angelo, do you have any final comments other than that I'm no good?
No. Just anyone that's listening, if you need to do something, just stick behind it. Go after the Nike commercial. Just do it. Don't be bogged down. And, you might have some expensive lessons as you learn, but try and partner with somebody. Try and do a joint venture. But at the end of the day, if you don't do anything, nothing's going to happen, and you're better off just trying it, in my opinion.
Yeah, I agree with that. And even though we have a difference of opinion on the methodology they're using for lease options, I can tell you from talking to him, Angelo knows what he's talking about. And he's certainly, if you're doing a deal in Ohio, an attorney that, he'd be the first guy I would call, because he definitely knows what the ropes are. I would just, ask him, quite frankly, just like he said, how many of these clauses are we putting in there that we know aren't going to fly, but we're doing it for another reason, just so you have that full disclosure up front. And that's part of it. That's part of the game. You heard me say we do some of the same stuff, trying to get as far as the 18% and liquidated damages and all that's put in there for a reason, and very generically, because we're doing stuff in a lot of different states, and I don't always have the time to go through and figure out what the exact percentage is that you can collect in collections. But no, Angelo knows what he's talking about. There's no question. He's a lot sharper than I originally gave him credit for when he and I started fighting on Facebook several months ago.
Well, thank you.
Well, I mean that sincerely.
Hey, that's why I use them on all my deals.
Yeah. When I saw the lease option contract, I thought you were totally incompetent. I'm like, there's no way an attorney is going to put this thing out there and stand behind it, knowing what I know. And then it came out that was all part of the strategy. I was like, okay, well, as long as you knew it and that's why you did it, and it's a different, totally different scenario than what I thought I was walking into, which was that you didn't know. So that's very good. Bill, any final comments before we wrap this up?
Not from my end.
What kind of bacon are you having today?
Smoked, hickory smoked.
Hickory smoked today? Oh, man.
Absolutely.
All right. Well, listen, I want to thank all of our participants. Rob, if you have a final word, by all means, jump in. Thank you for participating. It's been certainly a pleasure. Bill, thank you. Angelo, I really appreciate this. I know that the people that are listening certainly appreciate hearing the different perspectives, especially since we've got a bar-certified attorney, a CPA, and other professional investors on here who've done tons of deals, just to give them some insight into the real world of how these things actually function and operate in practicality, and once everything goes bad. So thank you very much for your time. I sincerely appreciate it, and we'll look forward to doing the next one. Until then, guys, have a great evening.
Thank you, Ben. Bye.
Bye-bye.
You You've been listening to the Virtual Real Estate Investor Podcast with Vincent Polisi. If you've enjoyed this podcast, be sure to connect with Vincent at virtualrealestateinvestor.org, Facebook at facebook.com/virtual real estate investor, or at Vincent's private Facebook group at facebook.com/groups/virtual real estate investor.